What are some of the most important things that you learned through going through several of these large government investigations that you wish you would have known at the beginning?
It's a great question, and I should say these were expensive. We talked about expensive, both in terms of the amount of money spent defending the cases, but also in a couple of these in terms of the penalties that we ultimately got assessed against us. So it is truly big litigation and big investigations. A couple of takeaways, I think. This is particularly in reference to government investigations. Be patient. Don't develop your defenses too quickly. Make sure that you have all of your evidence, and make sure that you have a narrative that you're going to disclose to the investigators that makes sense, that is watertight, that is coherent, before you go out and begin to sort of expose those defenses. So take the time, be patient to develop the defense that you want. And then the very first time that you talk to an investigator, to the very last time that you talk to an investigator, whether it be testifying before Congress or making a petition to one of the agencies, be prepared. Understand what it is that they are after. How does that fit into the narrative that you've developed? How do you begin to try to shape that presentation so that it will hopefully represent advocacy in your favor? This is a very, very difficult thing to do because, of course, the sides have very different interests. There's not an alignment of interest between a government agency or a political agency that's investigating a large company and the company itself. So patience and being prepared, I think, are the two things that I've learned over the course of doing this. Intuitive, but harder to do when you're in the heat of the moment.
Mm-hmm. Now, as you guys have questions that pop into your head, maybe looking for some tips, I know I could use some on how to learn to be patient. Please be submitting those in the forum app. And Susie will come up here at the end and be your advocate so that you can all quiz Bruce as well. Maybe one thing we could talk a little bit more about at first is, how do you even get started? Like, how do you prepare a company for such a big investigation? And how do you manage the communications up and stay organized at the same time?
Yeah, great question. There are three stakeholders that I believe are critical to this process. The legal department and the general counsel is clearly one core stakeholder, but equally important, the CEO and the other executive members of the management team, but the CEO in particular. And then the third leg of this tripod, all equally important, is PR and whatever media organization your company has built to deal with brand issues, with reputational and publicity issues. Those three stakeholders have to work together, and they have to be in absolute coordination and in concert with one another. Developing that relationship early on, you could do sort of table exercises, you can sort of pre-plan these things, but just making sure that you understand nobody jumps the gun. It's part of being patient, right? When something like this breaks, you don't want the media guys getting ahead of the legal defense. You don't want the CEO tweeting something that's going to be embarrassing. You want to make sure that all of these groups are disciplined and understand that it's going to take a concerted effort before we do anything. So the San Bernardino case was a classic example of that. The company was under absolutely incredible pressure to cave and give the government what it was asking for. But Tim primarily held the reins and was very, very disciplined in saying, we are going to have one statement. This is 24 hours after we publicly opposed the government's request to create the back door. We're going to have one statement. I'm going to be the author of that statement, or the public author. It will be under my name. But we're going to have law, PR, and me draft this thing. And I remember we stayed up probably until 5 o'clock in the morning the night that we were going to release this, and then we released the statement and started a round of interviews immediately with the European press, because it was 5 a.m. in California, but it was still business day in Europe. So we spent 24 hours awake crafting this thing, released it, and then immediately began going to the press and doing interviews and explaining why we were doing this. So developing that trust and agreeing in advance that those are going to be the stakeholders and they're going to be working in concert, very important.
How does the personality of the CEO come into play in situations like that? You've obviously worked for a couple of larger-than-life people.
A couple of CEOs, yeah. Look, you can't overstate how important that is. At a number of levels, the CEO in really all matters, but particularly under this kind of crucible, is the best spokesman for the company. If you want to get somebody interviewed, if you want to have somebody testify, if you're going to talk to a regulator in Washington, D.C. or Brussels or Beijing, if the CEO is the point person, is the figurehead for the company, you're going to get the best kind of response. You'll get access to the best interviewers, you'll get access to the highest level politicians. And so bringing your CEO into this process and making sure that he or she is on board with what you're doing and is willing to provide the time and energy that it takes to be prepared to respond to these kinds of crises, very, very important. And I think obviously the CEO also sets a sort of cultural tone at the top of the company. And so if your CEO is calm in the face of this kind of attack, if the CEO is patient and demonstrates those characteristics, then that's going to help the entire team. But the CEO having a CEO on board in general, when you're, particularly in Washington or in Europe, if you have to go and make a presentation to a bunch of regulators, the general counsel gets you to level 4 out of 5, but won't get you to level 5. The CEO gets you access to the level 5 decision makers, and that in many cases can be the critical difference between success and failure.
And how do you choose the language or the tenor of the language in some of these statements? Like when I think back to San Bernardino, these were somewhat fiery words for a lawsuit. The FBI threw all decorum to the wind, these kinds of statements. Is that you channeling your inner litigator? Or is that a reflection of Tim's passion on the topic? Where does that come from, and how do you know how to chart the course that will get you to a good result, but still be somewhat restrained?
So I am probably most proud of the work that we did in the San Bernardino case for exactly the reasons that I just mentioned, that collaboration between PR, law, and the senior executive. What happened fairly early on was Apple realized that this was an existential moment in our existence. We were going to have to do something that could absolutely turn off a massive number of our customers and create a stain on the brand and the reputation of the company, or not. And at the same time, we needed to both expose what was happening in the litigation and be absolutely clear on our sympathy for the victims of the crime and our desire to do everything that we could reasonably do to avoid any kind of assistance to terrorists. And so what actually happened was you had two different narratives going on. You had Tim going on ABC television, being interviewed by David Muir, and being, I think, very, very compassionate and very soft in his approach, but explaining Apple's logic in saying that we cannot and will not endanger all of our customers by building this back door. And then you had me being really pretty aggressive in terms of the public reaction to the things that were coming out in the briefs. And both in writing and in my first set of testimony before the House Judiciary, one of the little threads that the government was running was Apple's doing this to sell more phones. Apple's doing this as a marketing ploy. And when that came up at the hearing, I kind of lost it a little bit. But so we had two different tracks. Tim took the very measured, speaking for the company voice. I took the more somewhat outraged. You guys you're not being fair in terms of the way you're characterizing our position.
Do you feel like, as you left, Apple's relationship with the FBI was on better footing, or?
I think so, absolutely. I mean, it's no lie that for a large period of time, I had Jim Comey and Jim Baker's numbers on speed dial, right? I mean, so this was not. There were times when we were very much adversaries, and but underlying that was a very long tradition of Apple working with the FBI to resolve crimes, both terrorist incidents and kidnappings, murders, things that are really horrific crimes, not quite as visible as a terrorist attack, but equally important. I mean, we had a long tradition of working with the FBI and a very good relationship with the FBI. And I think that one of the things that came out of this also is that we said we can't build this back door, and I think a lot of people ultimately understood why. But what we will do is to meet with the FBI and do exercises to train both local law enforcement, local police departments, and the FBI on what can you get from phones. There was an incident. There's a little piece of the San Bernardino case, which was that the FBI essentially did the wrong thing when they first got hold of the shooter's phone and foreclosed one particular avenue of getting to evidence. So our thought was, look, let's make sure that never happens again, that there are things you can get from phones in this situation, and let's make sure that everybody who's in that position knows how to do that. And so we started training people around the country to how to deal with phones when you come onto a crime scene and you see a phone there.
Right. I was talking to some of the conference participants yesterday, and this idea of training the government and helping people to be able to understand new technology. When you go to hearings and you hear questions that just make you know that the person who's doing the talking does not understand what your company does. Do you have any tips for how to accomplish that? How to get training out there, how to find the right people, how to escalate in dealing with those situations?
So this is a two-edged sword. I think it's incredibly important to offer to provide that kind of training. It's great if you can figure out the right way to do it. The other side of that is, in a lot of cases, you have not just the government, but you have a complainant who will try to challenge the things that you say about the technology. Mm-hmm. And so the danger is that you lose credibility by trying to teach. If the decision maker ultimately concludes that, yes, you're trying to educate me, but you're doing it from a slanted position, then you're in danger of losing more credibility than you had at the beginning. So you have to do this carefully. And I think the way that we've tried to do it is offer to do the training, offer to work with someone who is neutral in the dispute at hand, and say, well, tell us who you would like to have do this training. We will work with them to put together something which is not in any way talking down to you as if you don't understand the technology, but rather trying to just lay out the framework for how this problem, whether it's a market analysis or a technical analysis, how this problem arises. We've done that a couple of times. Apple's done that a couple of times in Washington, D.C., where we would go to, generally it's like the Young Democrats or the New Republicans, or it's people that are generally kind of at the entry level into Congress or in the Senate who are more interested in that. But we've said, let's agree on somebody, have as many other people as you want to be a participant, and let's develop a training that would help.
Right.
Yeah.
Obviously, things don't always go your way,
No,
right?
I wish.
Maybe you could talk about an example, maybe ebooks or something, where the decision came down What happened after that? How do you speak to the C-suite about that? How do they handle their disappointment? Does that change the relationship in any way? Like, how do you move forward after a bad outcome?
Yeah, we've had a couple of, ebooks was certainly one. The other spectacular, very visible loss was in the European state aid case, where the ultimate decision of the European Commission was that Apple owed $13 billion in back taxes. Not a small number.
Even for Apple?
Yeah, even for Apple, $13 billion is a lot of money. I think there's some pre-work that you want to do with your executive team and with your board to make sure that they understand the potential range of outcomes and that you've given them a very fair assessment to the best of your ability about what the probabilities will be for getting a good outcome versus getting a bad outcome. The more you could engage them in the process during the arc of the defense, the better I think it is in the end when you have a bad result, because I think people, they understand both the possibility of getting such a result, but also they've seen the development of the defenses, they've been aware of the way in which the case has been defended, and generally feel that there wasn't a mistake, there wasn't some error that was made by the legal team that resulted in a bad decision. So that part of sort of conditioning is important. It's also important that you get the authority to proceed with something early on. So in ebooks, which some of you may remember, but ebooks was when Apple introduced the iPad and developed a bookstore around the iPad that would compete with Amazon. And the model that we used was to essentially track Amazon's prices and developed a sort of highest price. So people who were selling books on our platform were limited, that they couldn't sell them for more on our platform than they could on Amazon's platform without some consequences. So it was a lowest minimum, was a highest maximum price, not a lowest minimum price, which is generally pro-competitive, saying there's a limit to how much you can charge for something. And it was in the face of a player that had 85% of the market, and we had 0% of the market. But for a number of reasons, ultimately the court found that there was an antitrust violation in the way that we'd set up this, the sort of puts and takes that resulted in these lower costs. Early on, the company decided that this is something that we were going to go to the mat on, that we felt it was sufficiently important that we not be perceived as having intentionally engaged in a price-setting activity. We firmly believed, and I still believe today, that there was no price-setting activity by Apple. There clearly was price-setting activity by the publishers who acted in concert, but we were unaware of that. So we didn't want to. We agreed that we weren't gonna settle that case. We were gonna fight the case as far as we could, and ultimately it was not granted cert by the Supreme Court. Unfortunately, I think this was at exactly the time when the Supreme Court was going through its own issues with the death of Justice Scalia, and so it was an 8-member court, and yeah. I think that probably may have had something to do with the non-grant of cert. But in any event, it was a decision that even though there was a substantial chance that we would lose, we were going to fight it. And if you look at the three-judge opinion in the Second Circuit, there are 2 judges that came out against us, and then 1 judge that came out entirely in our favor, and that was also in part of the calculus for saying, let's go ahead and see if we can take it up to the Supreme Court, because we had 1 very strong dissent, but very much along our lines, and then two judges that went against us.
And what did Tim say when you lost?
He said, this is the way things go, right? I mean, this is we fought the fight, and we still believe that we're we're innocent, but that's not our decision to make. Ultimately, it's the courts. On the other hand, you win $1 billion against Samsung, and Tim comes into my office and high-fives me. So,
Right.
you get the good with the bad.
Right. Well, good days and bad days.
Exactly.
Hopefully everyone is submitting some good questions via the forum app. Maybe in our last couple of minutes before we start asking questions for the audience, we could give us your take a little bit on the antitrust climate that you're seeing now, especially around big tech. I mean, do you feel like the app store model is at risk? Do you feel like people are going too far in Washington or not far enough?
Yeah, so I think we're entering a period of intense scrutiny and intense efforts to regulate. This is primarily in the tech space, but I think there's a potential for this to bleed over into a general large company, profitable, successful company issue as well. But we're seeing the sharp end of the spear right now is in tech, and obviously Facebook and Google are probably at the very point of that spear. I think it reflects a couple of different things that are going on in the country right now. I think it reflects a general political the bifurcation and the dysfunction that exists in our political system. People are looking for a way to make a name for themselves. People are looking for a scapegoat. People are looking for someone to go after. And when you marry that with concepts of the income inequality, with some of the carry-on from the tax issues that we've seen, very successful high-tech companies are a great place to start. That's not to suggest for a minute that there aren't things which need to be done in that space. I don't mean to suggest that high-tech companies should be immune from any kind of regulation. I just think that what we're going to see right now is a period of accelerated, more intense investigation for both political and legitimate purposes. As I said before, there often can be a misalignment between the interests of these parties, and while there's things that need to be done to protect citizens' privacy and to deal with the massive amount of data that we now have access to as large tech companies and make sure that that's treated appropriately, there's also a political benefit to being the person who goes after a Facebook or a Google or an Amazon or an Apple. So we have both of those at play. And I think that we're going to see that not only in the US, but I think it's going to be mirrored in Europe. And China's a different issue altogether, but we may see some aggressive enforcement in China as well.
Mm-hmm. Susie?
Yes, well, thank you very much. And we do have a few audience questions for you. And so first, Bruce, when investigations become public, what are some strategies for de-escalation?
So there's the famous Johnson & Johnson case. I mean, we've all probably learned about that, which basically stands for the proposition of being transparent and always erring on the side of overcompensating for the problem. That's hopefully a way to de-escalate. You have to be careful about how you pick that response. But generally, I think the more you can say, once the issue becomes public, the more likely you are to take the heat out of the problem. It doesn't necessarily mean that people will stop asking questions, and that gets back to this notion of be patient, be prepared, don't speak until you know that what you are going to say will survive scrutiny. But if the more you can say, and the more sincere you are in terms of the way you address the problem, then I think you take the fire out of it. You don't stop the discussion. But what you're trying to do at that point is actually, in a very sort of counterintuitive way, you're trying to use this problem as a way to reinforce the values of the company and to try to not injure the brand, but maybe even enhance the brand at some level because you've shown a responsible and very sensitive response to the problem, whatever it is. But I guess it would be transparency, tempered by patience and making sure that you have your narrative completely aligned, and then a general tendency to sort of overcorrect in the sense of, so a counterexample to J&J, some of you may remember at Intel, there was something called the microprocessor flaw. So there was a flaw in the Pentium processor that was going to produce an incorrect answer by one very, very, so like the 4th or 5th decimal point after the 0 in 1 in 11.5 million incidents. It would produce a wrong digit. And Intel's response was, come on, guys. I mean, this is like, really? It's the chances that anybody's ever going to hit this are so remote, that you could be struck by lightning the day you win the lottery before it would happen. But that was not sufficient because the population, the consumer said, we don't care. That's a problem. You're supposed to be responsible for making sure that this chip calculates correctly. And it doesn't matter how remote the possibility is. If I'm the person that gets that event, I don't want to buy your chips. And so Intel had to do a complete sort of turnaround and say, okay, mea culpa, we get it. We are going to fix this no matter what it takes. So transparency and tend to overcompensate.
That's very helpful. And I think we have time for one quick question. So in terms of asserting privilege, do you recommend trying to assert privilege over any part of internal PR conversations? Maybe
yes.
It's not a quick
yes.
question.
I think
this is a feistier one than it sounds like.
Yeah, right. Yes. I mean, I would, if indeed you have been successful in creating a tiger team inside your organization of the kind that I've described, where you have CEO, general counsel, and head of PR working as essentially the control group that's going to both create and then disseminate the corporation's position on something. I think that the privilege needs to apply because you need to be able to speak to your media director or your head of PR in the same way that you would to your CEO. And my sense is nobody would say, well, we should not assert the privilege over communications between the general counsel and the CEO. In this kind of situation, I think those communications between GC and head of media practice are just as critical to the strategy that's being developed by the company. That becomes more difficult to do in various places. So for example, in Europe, it can be very difficult to establish that privilege, and you have to act accordingly. But I think in the US, I would suggest that you should assert it, you shouldn't waive it, and if there's a First Amendment argument, which of course there is, I think it's one that needs to be fought.
Great, that's very helpful. Well, thank you both very much
for
joining us today.
Absolutely, it's a
Thanks
privilege.
for your questions, everybody.
Thank you.
Bruce Sewell.
Thank you.